Welcome back to the High Court Report, your one-stop shop for Supreme Court coverage. Today, we break down Mullin v. Doe, decided on June 25, 2026, 6-3, with a notable fracture inside that majority. Justice Alito wrote for the court. This was the second of two immigration cases handed down on June 25th.
The ruling strips federal courts of all power to police whether the Secretary of Homeland Security followed the TPS statute's own mandatory procedures when terminating temporary protected status. Justice Thomas joined and wrote separately, pushing far beyond where the majority stopped. Justice Kagan dissented, joined by Sotomayor and Jackson. For hundreds of thousands of immigrants from 13 countries, Syria, Haiti, and 11 others, the courthouse door just slammed shut.
Before we dive in, please follow, rate, subscribe, share, and review the podcast on Apple, Spotify, YouTube, anywhere you podcast. Just search the High Court Report. And if you have questions about this case, reach out via LinkedIn or email at scotus.cases.pod@gmail.com.
All right, here's what you need to know. As listeners may recall from our preview episode, we laid out the full stakes before oral argument on April 29th. 13 countries terminated. Hundreds of thousands of people. A Secretary of Homeland Security who terminated every single TPS designation that crossed her desk. Now we know how the court ruled.
And that April 29th argument, the very last day of the term, previewed this decision remarkably well. We'll trace those moments as we go. Quick foundation first. Congress created Temporary Protected Status, TPS, in 1990. Your home country collapses into war, earthquake, or catastrophe. You can stay in the United States legally, work legally, and avoid deportation while those dangerous conditions persist.
Before TPS, presidents did something similar with no written rules and zero judicial oversight. Critics called it arbitrary. Congress passed TPS to fix that. Specific criteria, specific procedures, mandatory consultation requirements, all baked into the statute.
And temporary turned into something else in practice.
Decades. Somalia received TPS in 1991 and still held it 35 years later.
Syria received TPS in 2012 because Assad's regime launched a brutal campaign against its own people, executions, torture, targeting of children. Haiti received TPS in 2010 after a catastrophic earthquake.
Syria held its designation for 14 years, Haiti for 16. Then Executive Order 14,159 arrived in January 2025. President Trump directed the Secretary to rein TPS in. Secretary Kristi Noem then terminated every single designation up for renewal. 13 in a row: Syria, Haiti, Venezuela, Somalia, Afghanistan, Burma, Ethiopia, Yemen, South Sudan, Cameroon, Nicaragua, Honduras, Nepal. No exceptions.
60 days notice each time.
September 2025, Syria's notice. November 2025, Haiti's, effective February 3, 2026. Both sets of TPS holders raced to federal court. Both district courts granted emergency orders pausing the terminations. Both circuit courts declined to stop those orders.
So the government raced to the Supreme Court, asked it to skip the courts of appeals entirely, and the court agreed. The court heard argument on April 29th, the final day of the term.
Walk me through the legal question.
The TPS statute contains a judicial review bar, a provision that strips courts of jurisdiction, meaning courts lose the power even to open the case. The exact language: there is no judicial review of any determination of the Secretary of Homeland Security with respect to the designation or termination or extension of a designation of a foreign state.
The central question: does that bar block only the Secretary's ultimate termination decision? Or does it also block challenges to the procedures she used, or skipped, to get there?
The TPS holders argued just the ultimate decision.
Right. Determination refers to the Secretary's factual conclusion about country conditions. Did Syria or Haiti still qualify? Courts cannot second-guess that call. But the mandatory procedures Congress wrote into the statute: consult appropriate agencies, review country conditions, publish 60-day Federal Register notice, those fall outside the bar. Courts can still police process even when they cannot touch the Secretary's substantive judgment.
The government argued the opposite.
Total bar. Any challenge to anything the Secretary did on the way to terminating TPS amounts to reviewing a determination. And at argument, that position got put under a bright light fast. Justice Sotomayor asked Solicitor General Sauer directly, Suppose the secretary posted a TPS termination on social media instead of the Federal Register, gave no 60-day notice, and consulted nobody. Court still cannot review that?
And Sauer said?
Correct.
He actually said correct.
He did. Then Justice Jackson escalated. What if the secretary pulled countries out of a hat to decide who loses TPS? Still no review. Sauer essentially said, Congress assumed that risk when it wrote, no judicial review of any determination.
And then Jackson asked the question that cut deepest. If the secretary can ignore every statutory procedure without any judicial check, what did Congress actually accomplish by writing those procedures into law?
Sauer's answer. Congress trusted the executive to follow the rules, backed by annual reporting and 18-month review cycles. Courts just do not enter the picture.
The liberal justices were not buying that.
Not at all. Justice Kagan pressed on the actual consultation in this case. One brief email from the Secretary's staff grouping Syria and Haiti with other countries, asking the State Department whether ending TPS raised foreign policy concerns.
State replied, no foreign policy concerns. Kagan pointed out the statute requires consultation about country conditions, whether Syria and Haiti remain dangerous. Those two subjects differ.
Then Kagan asked Sauer, what if the State Department's reply just talked about last night's baseball game? Would that satisfy the consultation requirement?
What did Sauer say?
He said, as long as the secretary asked the question, she consulted. Whether anyone answered on the right topic did not matter. Kagan called that divorced from the word's plain meaning.
She also raised the doctor analogy right there at the podium. If your doctor says he consulted a specialist before recommending surgery, you expect the specialist actually engaged on your condition.
An email that never got answered, or that came back about the Dodgers, means the doctor lied. The majority followed Sauer anyway.
Walk me through how.
Justice Alito built the majority's analysis around the word determination. Two ordinary meanings: a specific individual decision, or the entire chain of events leading to a final decision. Under either reading, the bar covers everything the TPS holders challenged. And the phrase, with respect to, the court pointed to Patel versus Garland, a 2022 case examining the scope of another immigration judicial review bar, generally has a broadening effect, ensuring the bar reaches everything relating to the termination, not just the termination itself.
3 arguments, 3 rejections. First, determination covers only substantive claims, not procedural ones. No built-in procedural, substantive distinction in that word. Second, determination secretly means only the Secretary's country conditions assessment. The court looked at the rest of the TPS statute and found determination appearing in multiple completely different contexts. Eligibility for benefits, admissibility, hardship findings, none touching country conditions.
Third, subsidiary steps like consultation fall outside a bar covering the ultimate determination. The court cited Army Corps of Engineers versus Hawks Company, a 2016 administrative law case, for the principle that subsidiary decisions merge into final agency action. If the final action escapes review, everything feeding into it escapes review too.
The dissent fired back on every single one of those points.
Hard. Kagan argued the majority stretched determination past its ordinary meaning. She pointed to the court's own ruling last term, EPA versus Calumet Shreveport Refining, a 2025 Clean Air Act case, which described determination as a term of everyday usage, meaning a decision arrived at. Not a decision plus the chain of events leading to it. A determination means a determination. Full stop. And she pressed the practical consequence. If the Secretary can ignore every mandatory procedure without judicial check, Congress wrote those procedures for nothing.
Now, the equal protection claim.
The Haitian plaintiffs argued statements by President Trump and Secretary Noam revealed racial animus behind Haiti's termination. The court analyzed that under Arlington Heights versus Metropolitan Housing Development Corporation, a 1977 fair housing case. Under that framework, racial discrimination need only form a motivating factor in a government decision. Not the dominant reason, not the only reason. One motivating factor among many suffices.
The majority said the Haitian plaintiffs still fell short, and the pivot the majority made deserves attention. The TPS holders spent considerable effort arguing the Secretary made a preordained, across-the-board decision to eliminate TPS for every country up for renewal, all 13. The majority turned that argument against them. That argument supplies the race-neutral explanation for Haiti. The administration opposed TPS as a program. 13 countries across East Asia, Central Asia, the Middle East, Africa, Central America, South America, and the Caribbean. Most people would call that a racially diverse group. Under the majority's reading, Haiti's termination followed from policy opposition, not race.
The dissent read those same facts very differently.
Diametrically. Kagan quoted statements the majority chose not to print. Haitians eating the dogs, the cats, the pets of Ohio residents. Haitians probably have AIDS. Haiti described as filthy, dirty, disgusting.
Haitian immigration called a death wish for our country. And why is it we only take people from shithole countries like Haiti and Somalia? Why cannot we have some people from Norway and Sweden?
Haitians are black. Norwegians and Swedes are not. Kagan made that point directly in the opinion. She wrote those statements fairly shout, in their racial undertones and overtones alike, that race entered into the president's resolve to remove Haitians from this country.
And Kagan argued the majority applied Arlington Heights backwards. That standard does not ask which motive dominated. It asks whether race formed any motivating factor. A race-neutral explanation does not wipe out a racial motive when both operate simultaneously.
Now dig into the voting fracture. You mentioned a split inside the 6.
A meaningful one. The 6-3 result covers most of the opinion, but Part 3A, the section explaining why the court could bypass the jurisdictional question and go straight to the equal protection merits for purposes of interim relief. Only 4 justices joined: Alito, Roberts, Thomas, and Kavanaugh.
Gorsuch and Barrett stepped off that section.
Completely. They joined the conclusion that the equal protection claim fails, but refused to endorse the analytical move of skipping the jurisdictional question to reach the merits. That fracture matters because Part 3A carries only 4 votes. Lower courts do not treat a 4-justice plurality section as controlling precedent.
The jurisdictional bypass reasoning remains contested law. And then Thomas went somewhere the rest of the majority would not follow. 2 moves the other 5 declined to make. First, Thomas argued the judicial review bar also eliminates constitutional claims, not just statutory ones. The majority assumed, and the government conceded, that a rule from Webster v. Doe, a 1988 case about a CIA employee's dismissal, requires Congress to expressly strip constitutional review before courts lose that power. Thomas said the TPS statute's no judicial review language does that expressly. No ambiguity, no additional analysis needed.
That puts Thomas well to the right of where even the majority landed.
Far to the right. If a future majority adopts Thomas's view, even the constitutional door currently left open by the majority disappears entirely. But Thomas did not stop there.
What else?
He challenged the entire legal foundation of the equal protection claim. The 14th Amendment's Equal Protection Clause applies to the states, not the federal government. The court extended equal protection to the federal government in Bowling versus Sharp, a 1954 school desegregation case, by reading equal protection into the Fifth Amendment's Due Process Clause.
Thomas called Bowling wrong. The Fifth Amendment contains no such guarantee. Reading one in makes the 14th Amendment's separate Equal Protection Clause redundant. And even if the Due Process Clause prohibited some discrimination, TPS represents a government-created privilege, not a constitutional right to life, liberty, or property. No property right, no constitutional hook.
That argument, if adopted by a majority, eliminates every equal protection challenge to a federal immigration decision.
Everyone. Which explains why Kagan, Sotomayor, and Jackson did not simply disagree with the majority. They wrote as if they saw Thomas's concurrence as a roadmap for where this court might ultimately land, and pushed back accordingly.
All right, what this actually means. The courthouse door closed. 13 countries terminated. Hundreds of thousands of TPS holders from those countries no longer have courts available to stop the process by arguing the Secretary violated the statute's own procedures. Before today, litigation bought time. Courts could pause terminations while challenges played out. After today, that buffer disappears on statutory grounds.
What about constitutional challenges?
Technically still alive, but narrowing. The majority left the question open. Thomas's concurrence targets that remaining opening. And even the majority ruled the Haitian plaintiff's equal protection claim fails on its merits, setting a steep bar for future constitutional challengers even if the door technically stays ajar.
The Gorsuch-Barrett fracture on Part 3A, what should courts make of that?
Treat it carefully. Lower courts received a 6-3 result on the judicial review bar, but only 4 votes on the reasoning about skipping jurisdictional questions to reach constitutional merits. Courts will have to navigate that issue fresh in future cases. Gorsuch and Barrett's silence signals genuine unease with that analytical shortcut.
For businesses employing TPS workers, the litigation buffer ends. Industries across healthcare, construction, agriculture, and research, employers of TPS workers from 13 countries face workforce disruption with no judicial mechanism to pause the process. The legal lever those employers and workers could pull no longer exists.
Ukraine's TPS designation extends through October 2026.
The court flagged Ukraine directly. No predominantly white nation faced termination under this administration. The Haitian plaintiffs made that point. The majority replied, Ukraine just has not come up for renewal yet. If and when it does, and if the administration terminates it, that test case may force a completely different equal protection analysis. Bottom line,
6 justices held that Congress stripped courts of all power to check whether the Secretary followed the law when ending TPS. 3 justices said the majority misread the statute and ignored strong evidence of racial animus. The word temporary in temporary protected status now means exactly what the Secretary says it means. When she says it, with no court empowered to disagree. Thanks for listening to today's High Court Report episode. Remember, please follow, rate, subscribe, share, and review the podcast on Apple, Spotify, YouTube, anywhere you podcast. Just search the High Court Report. And if you have questions about this case, reach out via LinkedIn or email at scotus.cases.pod@gmail.com. If you caught our preview episode on this case, the stakes landed exactly as high as we described. Talk to you soon.